Greetings and welcome to Law of Evidence, Judicial Notice. This is the Procedures and Actions section of the Judicial Notice chapter of Evidence in American Jurisprudence. So if you're just joining, we've been going through the Law of Evidence and we're on the section with Judicial Notice. Let's get down to the text, and if you just got in here, please hit the like, make sure we get the message out there, as it seems the notifications were rather thin tonight. With that said, let's get started. So as we said here, we're on to the second section of the chapter on judicial notice, and we're on section 36, generally. At any stage of the proceedings under both federal and state law, a court may take judicial notice of an adjudicative fact, which is a proper subject of such notice, whether requested by a party or not. So as we learned before, the adjudicative fact, and before I even get to that, I want to just remind everyone that this broadcast is strictly for the entertainment, educational purposes of this YouTube channel here, not to be used, misconstrued, or mispurposed for anything professional, personal, legal, lawful, financial, tax, or otherwise. So please don't do this at home. That being said, let's continue. So the adjudicative fact is one of those facts that should be able to be proven without dispute, and that the court would recognize, but only in this particular instance with these parties, all right, which is a proper subject of such notice when requested by a party or not. So a court can take a judicial notice whether it's requested by the party or not. So courts may take judicial notice of matters of common knowledge, although not pleaded. So this is upon, when they say the courts may take judicial notice, is typically the judge. The burden of persuasion, where a court acts sua sponte, so when they act spontaneously on their own accord, where a court acts sua sponte to take judicial notice, rests upon the party who bears the burden of persuasion on the factual proposition which the noticed fact tends to establish. So as we learn here, the burden of persuasion, where a court acts sua sponte to take judicial notice, rests upon the party who bears the burden of persuasion. So even if the court acts on its own, the party that bears the burden of persuasion, or they're trying to move the court, I guess, in this situation here, on the factual proposition which the notice fact tends to establish. So they have the burden of persuasion. As we learned before, sometimes the judicial notice, although it may be a fact, may not actually be interpreted in the way the party that puts forth that judicial notice intended it to be construed. And it gets used for a different purpose than the intended use of the judicial notice for the original party filing it. Ordinarily, a party seeking to take advantage of a judicial notice in the course of presenting evidence in the case should bring the matter it wants judicially noticed to the attention of the court, so that if there is a ground upon which it may be contradicted or explained, the adverse party will be afforded an opportunity to do so. So let's keep this part in mind, a little foreshadowing here. Ordinarily, the party seeking to take advantage of the judicial notice in the court of presenting evidence in the case should bring the matter it wants judicially noticed to the attention of the court, so that if there is a ground upon which may be contradicted or explained, the adverse party will be afforded an opportunity to do so. In other words, making sure it's brought forth directly to the court so that it can be contradicted or explained, and the adverse party will have an opportunity to have their opportunity to object or to acknowledge it. Judicial notice is not judicial knowledge. and one having the burden of establishing a fact of which a court may take judicial notice is not, in consequence, relieves of the necessity of bringing the fact to the knowledge of the court. Judicial notice is not judicial knowledge. Interesting. So one having the burden of establishing a fact of which a court may take judicial notice is not, in consequence, relieved of the necessity of bringing the fact to the knowledge of the court. So it's not enough just have judicial notice. You also have to bring the fact of knowledge to the court. So it's judicial notice and judicial knowledge. Judicial notice is this explanation of or stating the facts, and bringing that fact to the knowledge of the court is, what we're going to get into here. So on to section 37, the discretion of court. Before we get into this, let's jump over here to the chat and see if anyone has joined us. And it looks like, once again, pretty thin on notification. That being said, let's continue. Discretion of court. Courts may not shut their minds to truths that all others can see and understand, and are not at liberty to entirely disregard facts of general knowledge of which the courts are cognizant. Moreover, in some jurisdictions, statutes expressly require courts to take judicial notice of specified matters. In the absence of a statute specifying matters of which judicial notice must be taken, it is discretionary with the trial court whether it will take judicial notice of well-established matters of fact. As a matter of fact, the court's rulings, usually depending upon the nature of the subject, the issue involved, the apparent justice, and the circumstances of the particular case. So there we go. The court's rulings usually depend upon the nature of the subject, the issue involved, the apparent justice, and the circumstances of the particular case. In exercising its discretionary power, court should proceed with great caution, and every reasonable doubt as to the propriety of exercise in a given case should be resolved against it. So, every reasonable doubt as to the propriety of its exercise in a given case should be resolved against it. That discretionary power. For example, to take judicial notice of a criminal investigation file which typically contains hearsay, rumors, conclusions, and documents or photographs that may have an insufficient foundation to be admitted into evidence would probably be an abuse of discretion. Yeah, I'd say. A court must take judicial notice of a fact where a party so requests, and the court is supplied with the proper information under both federal and state rules. A court may decline to take judicial notice of facts, even if the information is readily verifiable, when it is not supplied with the necessary information. Footnote 43. Association Against Discrimination in Employment, City of Bridgeport. Oh gosh, look at this thing. That's a tangled mess there. All right, let's get back up to our observation here. One of the nice little features here with American jurisprudence, to give more clarity to the subject. In order to justify a reversal in a criminal action on the grounds the court refused to take judicial notice of a particular fact, an accused must show, all right, here's our checklist. 1, the trial court abused its discretion. Here we are with discretion as our topic here, by failing to take judicial notice of the fact. 2, he was prohibited by the trial court from establishing the fact by other competent evidence. Okay, so must show, all of these. And 3, because of its relevance to a material issue, the exclusion of the fact resulted in harm to the accused. So there it is. In order to justify a reversal in a criminal action, on the grounds the court refused to take judicial notice of a particular fact. And this comes from footnote 44. And here's that case is James versus State, Texas. All right. Excellent chapter. Let's see if we have any other footnotes here that have captions with them. Otherwise, it's just the cases. All right. So we're on to section 38. Again, now we're into the procedures and actions. Opportunity to be heard. Procedural protection is provided for a party who would be adversely affected by judicial notice of an adjudicative fact. It is if a timely request is made, a party must be given an opportunity to challenge the propriety of taking judicial notice and the tenor of the matter, noticed under both federal rules of evidence and corresponding state statutes. To afford this opportunity, the court should, on the record, in advance of taking notice, identify the fact it contemplates noticing and its justification for doing so. Normally, such opportunity would come before a court decides to take judicial notice. But in the absence of prior notification, the request may be made after judicial notice has been taken. The latter situation is likely to arise only when a court takes judicial notice sua sponte, so when the court does it on their own. Then, as the notice is, I guess the parties would notice the notice was taken there, and then they would have an opportunity to be heard. A state court may also require that a party affected by a court's taking judicial notice of a fact be entitled to an opportunity to be heard, and that when a court finds it appropriate to take judicial notice of a matter, fundamental fairness dictates that it should provide the parties with advance notice of its intentions. So when a court finds it appropriate to take judicial notice of a matter, fundamental fairness dictates, great language here, guys, that it should provide the parties with advance notice of its intentions. And that's footnote 51. Chazalo versus Board of Assessors. Indeed. Caution. The failure to specifically object to a court taking judicial notice may constitute a waiver of the objection. Some state courts go further, providing that a trial court must conduct a hearing on the propriety of taking judicial notice and the scope of the matter to be noticed when a party seeking to have a fact judicially noticed faces a challenge from the opposing party. Furthermore, a court should not take judicial notice at a hearing at which parties are not presented by counsel. Normally, the taking of judicial notice under these circumstances violates the due process rights of the parties. Wow. So, again, they need to make sure all the parties represented. Wow. Not represented by counsel. So even if they're present, if they're not represented by counsel, the court should not take judicial notice at a hearing. Footnote 54. That's a case in Montana. All right. That's an interesting one there. Normally, the taking of judicial notice under these circumstances violates the due process rights of the parties. Okay, so yeah. Since a court may take judicial notice at any stage of the proceedings, a court may take judicial notice of a fact after the close of evidence. And this does not preclude a party's opportunity to be heard on the matter, because once the party receives the trial court's order, the party can make a timely request for an opportunity to be heard on the matter. Wow. So judicial notice taken at any stage of the proceedings. It may take judicial notice of a fact after the close of evidence. But it doesn't preclude the party's opportunity to be heard. Even after the evidence has been, the close of the evidence, you'd still have an opportunity to be heard on the matter. The party can make a timely request for an opportunity to be heard on the matter. So Be aware. That's another part of a caution, it seems. We're on the footnotes here. Bonifay versus Garner, and that's Florida. Each holding it improper for a judge to judicially notice facts without affording parties notice and opportunity to be heard. All right, here's another one here. Although when a court acts sua sponte to take judicial notice, the burden of persuasion rests upon the party who bears the burden of persuasion on the factual proposition which the notice facts tends to establish. Procedural fairness demands an opportunity to be heard on a propriety of taking judicial notice. So, it seems like demands an opportunity to be heard. No matter put in issue by the pleadings can be considered undisputed for purposes of judicial notice, because the trial court did not require evidence of the disputed rules and regulation it had not basis. Let me read this again. These are always abstracts. Because the trial court did not require evidence of the disputed rules and regulation, it had not basis for determining exactly what it was judicially noticing. It had not basis. Okay. I'm reading that correctly. Effects of pleading, section 39. All right, let's jump over here to the chat. I don't know if this thing needs. Oh, there we go. Holy goodness. Wasn't refreshing, and now it is. So here, let me get to the chat. Greetings, Metal. St. Frog Dog. All right. Bill Thomas says most ex parte actions of the court are sus. Yeah, they typically are ex parte. Indeed. All right, let's proceed here on the effects of pleadings. Courts are in disagreement over whether a party must present in her pleadings matters she seeks to have judicially noticed. Courts are in disagreement whether the party must present in the effects of the pleadings and judicial notice. Wow. Didn't know this one. Some courts state that matters of which judicial notice may be taken need not be stated in the pleadings. The court will consider such matters, although not pleaded. In federal courts, a party is not required to plead matters which he wishes to have judicially noticed. These jurisdictions also provide that judicial notice will be taken of well-established matters of common knowledge, even though the pleadings contain allegations to the contrary, and that pleadings, both civil and criminal, must be read in the light of facts of which the court takes judicial notice. When facts alleged are out of harmony, or inconsistent with, or contrary to facts of which courts take judicial notice, the facts alleged will be disregarded. Wow. All right, let's see here. I need to see this one here. The court's disagreement in her pleadings matters she seeks to have judicially noticed. Footnote 57 is the only one then, huh? Dillard versus McKnight. Okay, West Virginia. As the necessity of pleading or notice under the Uniform Judicial Notice of Foreign Law Act. Whew. Oh, gosh. Okay, so if you're doing anything under the Uniform Judicial Notice of Foreign Law Act, then that would be on Section 109. We don't intend to get there tonight. Quite often, all right, see, that's interesting observation here. When facts alleged are out of harmony or inconsistent with or contrary to facts of which courts take judicial notice. The facts alleged, if they're inconsistent, out of harmony, contrary to, then those facts alleged will be disregarded. Other courts apply different rules, stating that the doctrine of judicial notice does not obviate the necessity for the proper framing of issues, whether of fact or of law. And facts cannot be proven by evidence or established by judicial notice until and unless they are properly pleaded. Wow. Cannot be proven by evidence or established by judicial notice. So you prove by evidence, established by judicial notice. Good language here to take note of. Until and unless they are properly pleaded. Consequently, a trial court properly refuses to take judicial notice of federal regulations presented by a party in support of its contract claims when all the party alleges that the guidelines were violated, but does not argue how this violation violated any of the terms of the contract at issue. So this is where the trial court properly refuses to take judicial notice of federal regulations presented by a party when all the party alleges that the guidelines were violated, but does not argue how this violation violated any terms of the contract at issue. Oh. So the federal regulations, there was no stipulation in the contract that referred back to the federal regulations, and then they try to use judicial notice, and then that was not noticed because the trial court refused to take notice. Wow. Good approach there. Let's see. Atlantic Richfield, of course, versus Canaan Oil. Oil companies fighting. Yeah, all right. So that's interesting there. A third approach is that a trial court is not precluded from judicially noticing a statute or regulation of another jurisdiction on the basis that it had not been pleaded. Although a party seeking to recover on the grounds of negligence per se must plead a statutory violation. Wow. So this one here is that a trial court is not precluded from judicially noticing a statute. So here's where they can, on the basis that it has not been pleaded. So it could still be noticed even though it wasn't pleaded. Although a party seeking to recover on the grounds of negligence per se must plead a statutory violation. Okay. So I get it, if that's part of the negligence there. The use of judicial notice at the pleading stage should be severely limited. Furthermore, no matter put in issue by the pleadings can be considered undisputed for purposes of judicial notice. A court may, however, properly take notice of the rules of the United States Supreme Court at the pleading stage. Wow. 67. Johnson versus Lehman. That's what Pennsylvania Commonwealth. That's an interesting one there. A court may, however, properly take notice of the rules of the United States Supreme Court at the pleading stage. Now that's quite intriguing there. And that'd probably be an interesting case to dive a bit deeper into. All right, let's jump over here to the chat before we get to the next section here. Obviate is defined slightly differently by Oxford versus Webster. Is there a legal definition for obviate? Yeah, there is. I'm surprised there was a difference in it. Okay, so I'm trying to think of my Latin prefixes, but they escape me at the moment. So let's jump over here to Black's and find it. So the pronunciation, and we're looking for obviate. So that should be somewhere around here. We just have to bear with the scanned document here. It takes a while to catch up. In the meantime, we might find some serendipitous definitions along the way. All right, we're on D, E, F. We're getting there. Let's try about there. Try about there. All right. Thanks for bearing with me here. All I'm doing here is check over the chat. Yeah, Bill Thomas says prevent versus remove. We're going to find out for sure here. It's pending lawsuit. All right. I'm going to move faster than this. Ends. Oh, wait a second. Oh, here we go. Here's a great word right here. We got to look at this one here. Officious intermeddler, 18th century. A person who confers a benefit on another without being requested or having a legal duty to do so, and who therefore has no legal grounds to demand restitution for the benefit conferred, sometimes shortened to intermeddler. Also termed archaically volunteer. Yeah, that's a pretty good term there to know. All right, obviate. All right, here we go. We should be close to it now. Obnoxious, observer, obviate. Here we go. Let's see if we're on screen fully. Yes, indeed. 16th century, to dispose of or do away with a thing, to anticipate and prevent from arising. So prevent, huh? They obviated the growing problem through legislation. 2. To make unnecessary. The movement obviated the all-night drafting session by getting the opponent to agree to an extension. So to make unnecessary, right? And that's, I guess, in the same vein as to prevent. To prevent that all-night drafting session. Here is the growing problem that was obviated. So it sounds like to remove, in a sense, is to make unnecessary, and the action of removing is what you do when you're obviating, but obviating is a more general term, it seems, to dispose of or do away with a thing, to anticipate and prevent from arising. And that's all in the same definition. So it seems, from an level of abstraction, it would be at a level that would have some implied intent along with it, of to getting rid of something that's not needed. All right. With that said, let's get back over to the text. Absolutely, Bill Thomas. That's what we're here for. Make sure that no word is left behind. All right, let's get back over here to the discovery motions. Now, this is a real exciting part here. Section 40, discovery motions. Where a movement challenges a party's right to discover particular information. The issue in jurisdictions with liberal rules is whether the information sought appears reasonably calculated to lead to the discovery of admissible evidence. A judge may judicially notice information in making this assessment that could not properly be noticed as adjudicative fact at trial. For example, while a court may take judicial notice of the physical record in a prior suit before the same court when determining if an action before the court complies with the applicable renewal statute, the court is precluded from according judicial notice to admissions made in the prior case. You could look at the physical record, but not the admissions made. Wow. Footnote 70, Mumford versus Davis in Georgia, Fulton County. All right, that's an interesting one there, and that's judicial notice involving discovery motions. Challenging a party's right to discover particular information. Jurisdictions with liberal rules. Oh, that's interesting there. Judge may judicially notice information in making this assessment that could not be properly noticed as an adjudicative fact at trial. Wow. So I wonder what the details on that one are. Here we go. Section 41, summary judgment and similar motions. In deciding a motion for summary judgment, a federal district court may, sua sponte, take judicial notice of adjudicative facts pursuant to the federal rules of evidence. As long as they have to follow. Wow. Okay. However, a party disputes the fact in question, it is generally improper for the court to notice it. If, however, a party disputes the fact in question, it is generally improper for the court to notice it. The judicial notice is proper only if the fact is not subject to reasonable dispute. For example, a court may not take judicial notice in considering a motion for summary judgment of events occurring at a prior hearing where the parties do not agree what happened and the hearing was not recorded. So a court may not take judicial notice in considering a motion for summary judgment of events occurring at a prior hearing where the parties do not agree what happened and the hearing was not recorded. Footnote 75. Levitt versus Adams. That's Texas. All right, well, that's an interesting aspect right there. In addition, the adversely affected party must have an opportunity to oppose judicial notice of the fact. In both state and federal courts, even when an adjudicative fact is judicially noticeable, it may be improper to accept as conclusive a second fact that is inferred from the noticed fact. Wow. So both state and federal courts, even when an adjudicative fact is judicially noticeable, so it may be improper to accept as conclusive a second fact that is inferred from the noticed fact. Okay, so they don't want to be inferring because, as we remember, it's not necessarily conclusive just because it's noticed. So to make a second fact as conclusive when the first one isn't necessarily just because it's noticed. Where the issue before the court is primarily one of policy rather than fact, however, judicial notice is more likely to involve legislative rather than adjudicative facts, and the restrictions that govern the latter do not apply. So, when the issue before the court is one of policy rather than fact, of core issues usually, that would affect the public, then legislative, ones that affect in a broader set, not just the parties in this action or the subject matter in the particular instance. Those would be adjudicative facts noticed, but the legislative would be more broadly applied, so that would apply more to the policy. The same dichotomy, adjudicative versus non-adjudicative fact, governs the propriety of judicial notice in determining whether the court has jurisdiction to hear the suit. Wow. Adjudicative facts may be noted only if Rule 201 or comparable standards are satisfied, whether the issue focuses on geographic jurisdiction or subject matter jurisdiction. Geographic jurisdiction, territorial, right? Or subject matter jurisdiction. Where the question is one of policy mixed with fact, however, a court may exercise its much broader discretion to notice legislative facts. Interesting there. So here's where that discretion comes in again. That's when they get to exercise it, when the policy is mixed fact. And I mean, it's when the question is mixed policy and fact. Then the court gets to have more discretion. All right, so here's our footnotes. Companion case, Americans. Let's see here. The judicially noticed fact of the Klan's policy of violence against African Americans, without more, would not suffice to permit an inference that the defendant was involved in firebombing the plaintiff's home. Gosh. All right. The court took judicial notice of the defendant county's practices in mailing rejection notices, but refused to judicially notice the inference urged by the county that the practice was actually followed in the instant case. So in California, let's see, we have here, see, Oceanside. concerning judicial notice of jurisdiction and venue, see Section 80. And regarding geography and venue generally, see Section 75 to 82. And those will be hopefully in later editions. And we're on to the jury instructions of conclusory effect of judicially noticed matters. The federal rules of evidence provide that in a civil action or proceeding, the court must instruct the jury to accept as conclusive any fact judicially noticed. Oh, civil action, right. Okay, so in the criminal, not necessarily, I think we read earlier. So the federal rules of evidence provide that in a civil action or proceeding, the court must instruct the jury to accept as conclusive any fact judicially noticed. A state's rules of evidence may provide that a court must instruct the jury to accept as conclusive any fact judicially noticed. That once judicially noticed, an undisputed fact becomes a matter of law. The vast majority of American jurisdictions have rejected the approach that judicial notice ought to operate as a powerful but rebuttable presumption. But it still prevails in few states that have not adopted the federal rules of evidence. The reasoning behind this opposing view is that judicial notice meets the objective of establishing facts to which the offered evidence would normally be directed, and that consequently, judicial notice relieves a party only of having to offer proof on the matter. It does not constitute conclusive proof of the matter, nor is the opposing party prevented from offering evidence disputing the matter established by judicial notice. So even if it's judicially noticed, it can still be challenged. So that's an interesting perspective. That's footnote 87. Okay, so no other notes on the footnotes. And that takes us to section 43, the criminal cases. Let's jump over here to the chat really quick and make sure. Bill Thomas says the officious intermeddler is likely to encroach on your liberty. Indeed. And they're all over the place. All right. Let me just make sure this is refreshed here, because the chat likes to stall on us here. And there it is. Okay. Criminal cases, section 43. There is a division of opinion as to whether a judge should instruct a criminal jury that it must accept a judicially noticed fact as conclusive, or whether a criminal jury should be told that it can reject the noticed fact. The federal rules of evidence provide that in a criminal case, the court shall instruct the jury that it may, but is not required to, accept conclusive any fact judicially noticed. In contrast, the uniform rules of evidence provide that a court must instruct the jury to accept any fact judicially noticed as conclusive. Some states follow the uniform rules instruction regarding the conclusiveness of judicial notice in a criminal case, while other states follow the federal lead in requiring a permissive rather than a conclusive jury instruction. So that's the difference between the criminal and the civil. As it seems like there's depending on the jurisdiction, but the federal rules provide that in a criminal case, a court shall instruct the jury that it may but is not required to accept as conclusive any fact judicially noticed. Okay, so we've read this over and over. What constitutes adjudicative facts within the meaning of evidence concerning, okay, that's just referring us to that. And now we're on notice taken post-verdict or on appeal. Now we're getting some detailed stuff here. Let's see what this is all about. A judicially noticeable fact may be noticed for the first time post-verdict or by an appellate court. Okay. And the federal rules of evidence provide that judicial notice may be taken at any stage of the proceedings. Some state courts also allow a party to request judicial notice at any stage of the proceeding. There are no inherent restrictions on an appellate court's authority to take original judicial notice of a noticeable adjudicative fact so long as all the parties are afforded an opportunity to be heard on the propriety of judicial notice. Judicial notice cannot be used, however, to bring new issues into the case on appeal. And new issues. An appellate court's decision whether to take judicial notice of the record in a prior proceeding is entirely a matter of discretion. A rule providing that a court must take judicial notice if requested by a party and supplied with the necessary information is limited to the trial courts. Appellate courts notice and rely upon adjudicative facts to establish appellate jurisdiction to hear an appeal. 1. That's a footnote 1. Okay, to affirm or to reverse a ruling below, and even to initiate sua sponte, a new proceeding. Wow, so the appellate courts notice and rely upon, so they notice adjudicative facts to establish appellate jurisdiction, to hear an appeal, to affirm or reverse a ruling below, and even to initiate sua sponte, a new proceeding. Wow. A court is not obliged, on the other hand, to judicially notice information which a party should have but neglected to include in the record below. Therefore, although an appellate court may take judicial notice for the first time on appeal of facts which the trial court would have been authorized to notice, an appellate court is reluctant to take judicial notice when the trial court was not requested to do so, and was not given the opportunity to examine the source material. This rule prevents the unfairness that would flow from permitting one side to press an issue or theory on appeal that was not raised below. That's the lower court below. An appellate court may, however, take judicial notice of factual matters not previously presented to the trial court when the facts are capable of immediate and accurate demonstration by resort to easily accessible sources of indisputable accuracy. Easily accessible sources of indisputable accuracy. That would be like the Tribe channel on YouTube, right? In addition, a reviewing court may take judicial notice of events or facts which, while not appearing in the record, disclose that an issue has been mooted. In addition, a reviewing court may take judicial notice of events or facts which, while not appearing in the record, disclose that an issue has been mooted. It is, however, inappropriate to supply an essential element of proof by taking judicial notice of the fact of the appellate level, even though a trial judge could have taken judicial notice of the fact at trial. So you got to exhaust the trial part, and then get on to the appellate part. In other jurisdictions, an appellate court, in reviewing the proceedings in a trial court, is limited to the record that it is before it on appeal, and may take judicial notice only of facts that could have been properly judicially noticed by the trial judge, facts that are necessary to determine whether the appellate court has jurisdiction of the appeal and whether the appellant has taken a proper step to have the record timely and properly filed. Other courts will not take judicial notice of any matters not considered by the trial court. A court may take judicial notice that a party's appeal has been timely filed when the court obtained the standard file copy of the notice of appeal from the appropriate clerk's office, which indicates that the appeal was timely filed. All right, so we got some as to what adjudicative facts. We went over that. An appellate court may unquestionably take notice of facts not noticed by a trial court, and an appellate court may take judicial notice of whether an attorney holds a license to practice law in the state. Judicial notice may be taken at the appellate level as well as at the trial level. And of course, as we saw there, it's not a good idea to, if you haven't exhausted at least a trial level. Where the issue of judicial notice is raised for the first time on appeal, the appellate court is faced with a conflict between the policy that decisions ought not to run contrary to indisputable facts and the procedural policy that prohibits a party from raising issues on appeal that were not raised below. Okay, that's a nice distinction right there. So lastly, if its clerk's office had been closed due to heavy snow, thereby extending the time for perfecting the appeal. Oh gosh. Oh, it's snow. Heavy snow. Judicially notice the snow. An appellate court may take judicial notice of its own records in litigation interconnected with an appeal before it. The court cannot, however, notice material which, though available for notice by the trial court, has not been incorporated into the record on appeal. Important to keep that record solid. An appellate court may take judicial notice of a fact to the same extent as a trial court. An appellate court may not, however, take judicial notice of a fact that was not offered into evidence at the fact-finding level. All right, and then we're on to criminal appeals, section 45. Check here on the chat. See if you guys are still with me on this one. This is another densely informative chapter. However, these are really important aspects of evidence, and judicial notice is something that needs to be fully understood to really see how the courts can move without having to go through the whole controversy process to get the case moving ahead for every little thing. So it keeps some of the pedantic issues out. It prevents meaningless arguments and things like that. So there's a lot of good that comes from judicial notice. Let's continue here on criminal appeals. In criminal cases, the federal rules of evidence and corresponding state statutes direct that the jury be told that it need not accept a judicially noticed fact as conclusive. This raises the question of whether an appellate court is precluded from taking judicial notice of an adjudicative fact in considering an appeal of a criminal conviction, where no request to take such notice was made during the jury trial. The federal rule providing that in a criminal case the court must instruct the jury that it may, but is not required to, accept a judicially noticed fact as conclusive, has been interpreted as precluding an appellate court from judicially noticing an adjudicative fact that the jury had not been given the opportunity to reject. Where sufficient evidence has been adduced at trial, an appellate court can take a judicial notice of adjudicative facts to reassure itself that the verdict below was factually correct. Moreover, it in no way violates the policies underlying the federal rule for an appellate court to take judicial notice of adjudicative facts on procedural trial issues or post-trial litigation unconnected to guilt or innocence. In addition, an appellate court should be free to take judicial notice of an adjudicative fact that benefits a defendant who is appearing in a conviction. Benefits the defendant who is appealing a conviction. That's footnote 20. In considering the defendant's claim that federal legislation and regulations preempted the state's right to prosecute, the court took judicial notice of records of the Merchant Vessel Documentation Division of the United States Coast Guard. Wow. Massachusetts versus Westcott. Federal legislation preempted the state's right to prosecute. The court took judicial notice of the records of the... Oh, wow. That looks like an interesting case here. That benefits a defendant who is appealing conviction. So they should be free to take notice. Again, that's the discretion of the court. And we're on to post-verdict events. Section 46. An appellate court may judicially notice an event that occurred after judgment was entered below if the facts noticed provide a basis to dismiss the case. But this is appropriate only if the notice fact unequivocally justifies such a result. Subsequent events that are not properly a part of the record on appeal should not be noticed. However, to expand the scope of review of matters which were disputed at the trial, except in extraordinary circumstances. 24 is an extraordinary circumstance. Colonial Penn Insurance versus Coyle. So that's in subsequent events that are not properly part of the record on appeal should not be noticed. Okay. However, to expand the scope of matters which were disputed, okay, except in extraordinary circumstances. Wow. I wonder what those could be. Here, this one here, the appellate court took judicial notice of ordinances passed 4 months after the trial court's action, which rendered appellate issues moot. Oh, wow. And to permit a party to appeal a decision on a basis completely different from that presented below would render the lower court's decision superfluous. Appellate notice of facts unavailable at the time of trial would be inconsistent with the appellate function of the court. Habeas corpus proceeding. Wow. Excellent. So we finished that. Now we're on to the next subsection here of specific matters judicially noticed. And on to, I guess this would be section, all right, so this is subchapter B, subsection 1 of the chapter on judicial notice. And this is occupational and business facts, which will be starting for the next edition. So with that said, we got a little sneak peek of what's to come. And let's jump over here to the chat and see what we got going here. Bill Thomas says he's attempting to follow this complex subject. Indeed, it is a complex subject. There's no doubt. The law of evidence, and we're just on the section, these last two sessions here have been strictly on judicial notice. So when you're looking at it from the whole context, we're seeing how much is being dedicated to this, the concept here of judicial notice. And the subject of judicial notices could be used to create difficult legal exam questions. Indeed. And you're seeing here how we're going over all the intricacies of it. You know, the adjudicative versus legislative, where the appellate courts can't notice facts that weren't noticed in the lower court because that would defeat the function of an appellate court to review the same facts that were looked at in the lower court. Presenting new facts through judicial notice without a fair opportunity to be heard would be going against the fairness of process and procedure, which is what the theme is here. And I think that's the essence of what it's come down to here. Now, that being said, I think we're going to continue to find out more and more through the law of evidence, because this is actually quite a long volume here in American jurisprudence, but an essential one when it comes to our understanding of the law. And as the saying goes, ignorance of the law is inexcusable. And we all have to be experts on the law to some degree. And I'm just trying to do my part here and sharing with a little bit of the knowledge here that can help us all expand our expertise. But that being said, this is strictly for entertainment and educational purposes, so don't misconstrue or use or misappropriate any of this to be used for legal, lawful, personal, private, financial, or tax otherwise purposes. And don't do this at home. With that being said, I'd like to thank you all for attending, and I hope to be able to continue this law of evidence and our sections here on judicial notice. This is a whole chapter, and we're almost done with it, so I thank you all and salute you for being here along for the long haul, and I think in the end it'll pay off for us all. That being said, I'll see you on the next one. Peace out.